Hi guys, welcome back to my channel. So today in this video I would like to continue my previous video entitled both liens and mortgages. So this is the second part of the video. Where the owners of a motor boat execute a chattel mortgage while the boat was being constructed and the mortgage was recorded in the country's recorders. In the country's recorder's office, but not in the office of the United States Collector of Customs. That mortgage was valid and enforceable until the boat was enrolled and duly licensed by the U.S. Department of Commerce. However, if after the boat was licensed as a vessel of the United States or documented, another chattel mortgage was executed to a person who had no actual notice of the prior mortgage, no mortgage which includes a vessel of the United States is valid against any person other than the mortgagor and any person having actual notice thereof, until such mortgage is recorded in the office of the Collector of Customs at the home port of such vessel. A federal statute provides that federal district court have original jurisdictions of a civil action brought to enforce a civil action in personam in admiralty against the mortgagor, maker, co-maker or guarantor for the amount of the outstanding indebtedness or indeficiency in full payment of the indebtedness. A civil action against the mortgagor, maker, co-maker or guarantor for the amount of outstanding indebtedness or any deficiency in full payment of the indebtedness, and a prior mortgage lien of a claim for the outstanding indebtedness secured by the mortgage vessel by exercising any other remedy, including an extrajudicial remedy. Thus, enforcement of the vessel mortgage is allowed in federal court only and may allow enforcement of mortgage right to sale of the vessel to satisfy both lien under federal law. A person providing necessaries to an already built vessel on the owner or a person authorized by the owner has a maritime lien on the vessel. The following persons are presumed to have authority to procure necessaries for a vessel: the owner, the master, a person entrusted with the management of the vessel at the port of supply, or an officers or agents appointed by the owner, a chatterer, an order to protect vice, or an agreed buyer in possession of the vessel. However, a person tortuously or unlawfully in possession or charge of a vessel has no authority to procure necessaries for the vessel, thus cannot create right to a lien on behalf of third parties. In Mackenzie v. the Jim Jet 2, 133 F sub 804-806 TNC 1955, the court held that any person furnishing repairs, supplies, or other necessaries to any vessel upon the order of the owner has a maritime lien on the vessel, and it's not necessary to allege or prove that credit was given to the vessel. Necessaries are furnished only if and when they are either actually delivered on board of or at sight of a vessel, or delivered to its owner or his authorized agent for the purpose of delivery to such vessel. The Denelfred 56 v. 2nd 213, Deming 1932. While a maritime lien may be waived by words or conduct indicating such an intention, the mere acceptance by a person who has furnished necessaries to a vessel or the promissory note of the owner of such vessel does not in itself constitute or result in such a waiver, unless shown to have been acceptance with the intentions to replace the lien within the promissory note. State law applicable to repairs of vessels. Contract for the constructions of a vessel and for the furnishing of materials are not maritime liens, and proceedings to enforce such lien come under state control and may be enforced in state courts. Globe Iron Works, Go v. the John B. Ketchum, 2nd, 100 Minch, 583 Minch, 1894. With respect to the application of this principle, no distinction is made between large and small vessels. A contract for building a vessel being a contract made on land and to be performed on land is not a maritime contract, and the lien to secure it given by a local statute is not a maritime lien and cannot therefore be enforced in admiralty. If the supply of machinery is deemed a part of the build of a vessel, the contract is not a maritime contract and cannot be enforced in an admiralty court. If the state law gives a lien for building a vessel, the lien can be enforced in the state courts alone. He 60 v. 2nd, 641 DNY 1932. For incidental repairs made on land to article of a ship's furniture or machinery, a court of admiralty does not have jurisdiction. Articles removed from a vessel and repaired or renovated upon land. For incidental repairs made on land to articles of a ship's furniture or machinery, a court of admiralty does not have jurisdiction. Article removed from a vessel and repaired or renovated upon land at the shop of the artisan are different from repairs made upon the vessel herself and are the subject of a possessory lien at common law. To Robert W. Patson, 191 U.S. 17. However, in Steamer Petrol v. Dumont, 28 Ohio Street, 602, Ohio, 1876, the court held that a contract for repairs of a boat at her home port on which a seat is brought in a maritime contract, on which a seat is in persona might be brought in admiralty court. The court further held that there can be no maritime lien without a maritime contract and no process in rem without a maritime lien. Also, a state law does not give a lien and process in rem against a boat different from all debts contracted on account thereof. Thus, the process and lien depends upon the contract, and without the contract, there would be neither process, lien, nor cause of action. Steamer Petrol v. Dumont, 28 Ohio Street. It is therefore the contract upon which the action is founded that determine the questions of jurisdiction, and if it is maritime, it falls within the admiralty and maritime jurisdiction covered by the U.S. District Courts. Conclusion. Most creditors would elect to utilize the efficient and rapidly moving federal court to seek relief, and depending on the state law, the power of liens of vessel is a powerful inducement for rapid resolution of claims. Likewise, most ocean-going vessels, including yachts, see advantage in becoming documented and thus subject to federal law in many instances. What is important to note, however, is state law applied to land operations and repairs. Thus the person facing such a transaction should take time to learn the law of the particular state in which the vessel is located. So, this is the end of the article. Don't forget to watch the previous video, and also don't forget to like, comment, and subscribe. Bye!